my lord. With the Court's permission, I request to call case number 163 of 2015. State versus Mayors, Oniso, and 4 others. They are all in custody.
May I please report, my lord, I appeal on behalf of accused number 1, 2, 3, and 5 in this matter.
May I please report, my lord, I appeal on behalf of accused number 4 in the matter.
Mr. Toba, is the court orderly fetching the accused?
That is correct.
While we wait for them, can you just tell me what the position is with the matter?
My lord, I've been requested by the royal planner to have this matter adjourned until next Thursday, the 28th of April. A judge will be allocated to deal with the matter by then, but it's just a provisional date on the 28th, and then the matter might have to start the day thereafter, my lord. They are back here in the South Gauteng, rather Gauteng local division, not in Palm Beach, but the Johannesburg High Court on the 28th.
So the trial will continue
Most
in
probably
close proximity to 28th day?
To 29th, the following day.
Or 29th.
That's correct. All 5 accused, my lord, are in custody. There is no bail. As a court basis.
May I please report, my lord, I confirm the arrangement of the matter will be postponed provisionally for the 28th. May I please mention that I'm not available on the 28th. Mr. Alexander has indicated that he will stand in for me until the next day or on the date that the trial will proceed.
Well, as long as someone comes who's appearing for the relevant accused who has authority to deal with the matter.
As it pleases the court, my lord, but I confirm the arrangement.
Yeah, so it's not going to run then, it will run the next day within close proximity.
Yes, indeed, sir.
Okay, so you're ready to carry on?
Indeed, sir, my lord.
I likewise confirm the arrangement.
Are you ready to carry
Likewise,
on?
my lord.
Right. On this matter, there is to be a remand until Thursday, the 28th April 2016. On that date, the matter will be called and will be allocated to proceed in close proximity to that date, perhaps on the 29th April. The state and the defence are ready to proceed. And the matter will proceed in this court, not in Palm Ridge.
Nge-28 manifika ke nizobizwa ningene liseliyahlehliswa lihlehliselwa ngakusasa wakhona nge-29 njengoba nge-28 ke selizothola ke ujaji walo ukuthi no linikezwa uphi ujaji nge-29 kusho ukuthi ke seliyaqala manje ukuthi iyakhulunywa nge-29 lapha elilandelayo ngokusho kwabameli labali babona bekhona besukuma kanjalo bonke nje bavumelana naleyo ndaba nalehlelo lelo ukuthi kunjalo bathembisa ukuthi no nabo bazabe bekhona ke sebezimisele ukuthi ke bazoqhubeka nge-29 mangabe ke kuzawuqhubekwa njengoba kubekwa ukuthi nge-29 lizawuqhubeka kepha nge-28 nizobuya nize futhi
hayi le judge wapha
My Lord, is your Lordship not going to be the presiding officer in this matter?
No.
Thank you very much. We can go.
Under the accused number 3 had certain issues regarding his attention at Krejcir's person. He's actually indicated to me that he's reduced it to writing. I might just be allowed to collect these presentations on writing before they go down in order to address issues therein if need be. Thank you.
So in this order, I make the following matter. The matter is remanded until 28th April 2016. All the accused are to remain in custody. The matter will proceed in close proximity to that date. Right. So the accused may go down.
As we wait for the court to proceed, the Czech fugitive Remand Krejcir and his 5 co-accused did get to know what is their fate. They'll have to wait another week for the court to proceed. That case was remanded until the 28th of April to find out whether or not they have leave to appeal in the High Court there. Now, as you know, the group is appealing their conviction and their sentence relating to a foiled 2013 drug deal. Krejcir was handed a 35-year sentence. His lawyers argued that his client did not receive a fair trial due to physical constraints. He also said that he was not awarded enough opportunity to prepare for the trial. Let's go back to the court now.
026 of 2014 State versus Radavan Krejcir and 5 others. The appearances are still as in before. We're ready to proceed.
Yes. In this matter, the 6 accused apply for leave to appeal against both the conviction and sentence. Accused 3 to 6, as part of the applications for leave to appeal, apply in terms of Section 316, bracket 5 and 6 of the Criminal Procedure Act 51 of 1977, that certain evidence which was admitted and produced during the sentence proceedings be considered as part of the evidence, and that its impact upon the application, its impact upon the evidence of one Lukele be taken into account in the appeal. That evidence is contained within an exhibit SP7, which was handed up during the course of sentencing proceedings. Exhibit SP7 constitutes a victim impact report of Becky Temba Lukele, which was compiled by one Ms. Bongiwe Dube. Within that report, the Mr. Lukele, who I refer to as the victim, was recorded as having said, in relation to the events surrounding his kidnapping, that, open inverted commas, the victim reported that Mr. Mofokeng showed him SAPS identity card and instructed him to open the gate, which he did. Close inverted commas. There were other incidental matters which were raised and which appear in paragraph 8 of the application of the applicants. At the time the document was admitted in evidence, the state and the defense agreed that the facts contained within the document were true and correct, that the opinions were properly made, and that the apposite opinion had been applied. During the course of the submissions made by the accused 3 to 6, counsel for them submitted that the evidence was common cause by reason of the admission which had been made, and that in fact he did not really need even to rely on the provisions of Section 316, as the evidence was admittedly before me. Mr. Mashiani, who appeared for the state, denied that the intention of his admission was that the ambit of the admission included evidence already led, which was in conflict with matters raised in the report. The counsel for the accused stated that the admission which had been made by the state was clear and unequivocal, and that there was no limitation upon the admission made by the state. I raised with counsel for the accused whether or not, if that was the position, the evidence which was contained within the document which was in conflict with evidence which was led at the trial, for example, that accused 6 had nothing to do with the matter, and that accused 6 was implicated in terms of the statement. His attitude was that this was an irrelevant question, and that in fact the only relevance was that it had been reported by Mr. Lukele, the victim, that Mofokeng was the person who had produced the identity card, whereas in his evidence Lukele had stated that the person who had produced the identity card was accused 4. There is no need, in view of my approach to the evidence, to decide the conflict between the state and the defence as to the ambit of the admission. I shall treat the matter as if the admission was made and included the statement that I have set out previously. The impact of the statement upon the case of accused number 4 is that whereas in the evidence given by Mr. Lukele had been identified as the person who had produced, Mr. Lukele identified accused 4 as the person who had produced the identity card and as one of the people who was implicated in the kidnapping. Whereas in the statement he is recorded as using the word Mofokeng in this regard. The name of accused number 4 is not Mofokeng. The name of accused number 6 is Mofokeng, and the submission was made that what had happened in the statement was that Mr. Lukele had referred to accused number 6 as being the person implicated, not accused 4. Hence, the identification of accused 4 on appeal would be considered in the light of this recanting by Mr. Lukele. In my view, this submission is ill-founded. It is to be recollected that during the course of the evidence, Mr. Lukele identified accused number 4 as the person who had kidnapped him by using the physical features of the accused and his observations in relation to the matter. At the time of those events, accused number 4 was unknown to him and was unknown as to person and name. Accordingly, the identification of accused number 4 by Lukele was dependent upon different matter than the name. The name being unknown to Lukele at the time of the events, the attribution of the name to accused 4 of Mofokeng is an ex post facto matter and does not impact whatsoever upon the observations and evidence given by Lukele in relation to the identity of accused number 4. Hence, in my view, the fact that Lukele referred to the person who attacked him as Mofokeng in no way impacts upon any of the conclusions which were made in the judgment. And the use of the word has no impact whatsoever. In addition, it is relevant to record that it is apparent from the document SP7 that there was no intention or no visible sign of an intention on the part of Lukele to change his evidence or in any way recant what his evidence had been. His evidence purported to be a description of what had taken place in relation to him and is accurate as was conceded by counsel in the other material respects. Accordingly, in my view, there is no merit in the submission made that there is any impact upon the approach of any appeal court by reason of the use of the word Mofokeng in annexure in Exhibit SP7. The submissions in relation to the applications for leave to appeal against conviction and sentence of all the accused covered the same grounds which had been covered during the course of the hearing and which had been submitted to me previously prior to me making the judgments which I did. In my view, there is no reasonable prospect of another court coming to a different conclusion, and it follows accordingly that all the applications made by all the accused as against conviction and sentence are dismissed.
Lord, may I just, at this point, place on record that I at no stage admitted the correctness of the identity of the description of accused 4 by Lukele. I at no stage admitted that. It's, as I understand your judgment.
I don't understand what
Your judgment, as I understand it, you said that it was admitted, conceded by counsel for 326, that Lukele correctly described accused number 4.
in his evidence.
Yes.
No, you didn't admit that.
I just want to make it.
It's no intention of me to say you admitted that what the evidence was correct. You didn't do that.
Thank you.
Right, the accused may be taken down. Court adjourns.